In the practice of real estate, disputes occasionally arise between licensees over commission entitlements, particularly in cross-sale transactions, where two different brokerages or agents are involved. Understanding how to handle these disagreements lawfully, professionally, and in accordance with the Arizona Revised Statutes and Commissioners' Rules is essential to maintaining integrity, avoiding disciplinary action, and preserving working relationships within the industry. Commission disputes typically occur when multiple parties believe they have earned the right to compensation for their role in a transaction. Common situations include dual agency misunderstandings, unclear commission sharing agreements, referral arrangements without written documentation, or cases where one party claims to have been the procuring cause of the sale. The guiding principle for resolving such disputes lies in ARS Section 322155, which governs the lawful payment of real estate commissions in Arizona. Under this statute, only a licensed broker may receive a commission for a real estate transaction, and only another broker may pay a commission to that licensee. This rule prevents salespersons from negotiating or receiving commissions directly and establishes the broker as the central authority for all compensation matters. When commission disputes occur between agents from different brokerages, it is the responsibility of the designated brokers, not the agents, to resolve the issue. Agents are prohibited from engaging in independent fee negotiations or withholding funds related to commission disagreements. For example, if a buyer's agent believes they were unfairly denied their share of commission after closing, that agent must notify their designated broker, who will then communicate directly with the listing broker to resolve the matter. Direct confrontation between agents or public disputes over commissions are considered unprofessional conduct under Commissioner's Rule R4-28-1101A, which requires all licensees to act with honesty, fairness, and integrity. Arizona law also provides that commission disputes cannot be resolved by the Arizona Department of Real Estate, ADRE. The department's jurisdiction is limited to matters of license law, consumer protection, and professional conduct. It does not serve as a forum for private financial disagreements between licensees. Instead, commission disputes must be settled either through the civil court system or by arbitration or mediation, if provided for in a written agreement between the parties. The Arizona Association of Realtors, AKR, offers a formal arbitration process for realtor members, which is often the most efficient and cost-effective means of resolution. For example, suppose a listing agent and a buyer's agent from different brokerages have a disagreement about the percentage of commission to be paid after a transaction closes. The buyer's broker may file for arbitration through AAR, provided both brokers are members. The hearing panel will review the facts, communications, and agreements between the brokers and determine which party was the procuring cause or entitled to the disputed amount. The decision rendered by arbitration is binding, and both parties must comply. Another frequent source of dispute arises when commission sharing agreements are not properly documented. According to R4-28-701, R4-28-1101B, brokers must recommend that all agreements, including compensation arrangements, be in writing to prevent misunderstandings. Verbal agreements or handshake deals, while common in informal practice, are not enforceable in court under the Arizona Statute of Frauds, ARS, Section 44-101, which requires all brokerage agreements for real estate commissions to be in writing and signed by the party to be charged. Thus, a broker who fails to document a commission split arrangement risks forfeiting the right to enforce payment later. Case law has reinforced this principle. In Phillips v. Arizona Real Estate Commission, 1979, a dispute arose over an alleged oral commission agreement between two cooperating brokers. The court held that because the agreement was not in writing, it was unenforceable under the statute of frauds. This case underscores the importance of written, signed compensation agreements, not only for compliance, but also for clarity in professional relationships. When disputes arise within the same brokerage, between agents under the same designated broker, the broker has full authority to determine commission allocation. Salespersons do not have independent contractual rights to commissions, as all commissions are paid to the broker, who may, in turn, disperse payment according to the terms of the employment or independent contractor agreement. Any internal disagreements must therefore be handled internally, and ADRE has no jurisdiction to intervene. To prevent commission disputes altogether, brokers and agents should take proactive measures, such as confirming co-brokerage agreements in writing, maintaining detailed communication records, and promptly addressing misunderstandings before closing. Additionally, R4-28-1103A requires brokers to establish written policies and procedures regarding the handling of commissions, ensuring that agents understand how disputes will be resolved within the brokerage and with cooperating firms. Review summary. Commission disputes are a common yet preventable challenge in Arizona real estate. Under ARS Section 322155, only brokers may receive and disperse commissions, and any disputes between agents must be handled at the broker level, not by ADRE. When brokers cannot resolve the issue privately, arbitration or civil litigation may be necessary. Written agreements are essential to enforce commission arrangements, as verbal promises are void under the statute of frauds. Maintaining professionalism, documentation, and clear communication are the best tools for preventing and resolving commission controversies. Discussion prompts. What is the first step an agent should take when a commission dispute arises? Answer: notify their designated broker immediately and allow the broker to communicate with the cooperating broker to seek resolution. Why does ADRE not intervene in commission disputes? Answer: because ADRE only regulates licensing and conduct, not private contractual or financial matters between licensees. Why is a written agreement necessary to enforce commission sharing between brokers? Answer: because under ARS Section 44101, the statute of frauds requires all commission agreements to be in writing to be legally enforceable. Closing remarks. Commission disputes test a licensee's professionalism, patience, and understanding of the law. Arizona's statutes and rules are designed to encourage communication and documentation rather than confrontation. A true professional addresses disagreements calmly through the proper channels and always within the framework of written agreements. The focus should remain on integrity, transparency, and cooperation, principles that define Arizona's standard for ethical real estate practice.